Hi, welcome to Been There Done That. This channel is all about employment tribunals, everything you might need to know and how to represent yourself. This video is about precedent and how that applies to your case, how you can use it to your benefit and everything that goes with that too. So precedent is just a fancy word that means someone else did it like that, so we need to do it like that now. Precedent applies to how judges make decisions in an employment tribunal. So there is the Employment Tribunal, the ET, and there is the Employment Appeals Tribunal, the EAT. And the EAT will review cases that have been appealed and have successfully been given a hearing with the Appeals Tribunal. And now it's not just a case of whether the judge made the right decision or not. It's a case of whether the decisions that those judges made should be being made ongoing in other cases. Employment Appeals Tribunal might look at a case where a judge has awarded a certain value for a certain thing, and then they might decide that actually, applying the law correctly, it would need to be done thus. Once they've made that decision at an Employment Appeal Tribunal, they have then set precedent. From that point forth, other judges in other employment tribunals must refer back to that appeal and that case to determine how they go forward with their decisions. A really good example of this is a very, very famous case called Vento versus Chief Constable of West Yorkshire. I mentioned this in another video where I discussed quite a lot about the Vento bans that came from this case. A bloke called Mr. Vento went to employment tribunal over his discrimination case. That case then went to the Employment Appeals Tribunal, and at the EAT they reviewed the compensation or the remedy that was awarded based on injury to feelings, and at that appeals tribunal they decided that they should be bans for injury to feeling, and they decided on the factors that would make you decide which ban these things fall into, and they decided on the bans themselves. So there are 3 bans: the low, the mid, the high, and determining whether a case falls into a low, mid or high range comes back to the precedent that was set in this case. Now, how this works for you is by finding cases where the precedent that was set at the appeals tribunal should have a say in what is done in your case. You need to do a lot of research. You need to go to the Employment Tribunal Decisions website, look at the EAT decisions and then read them. Look at the ones that might apply to you. You can filter by discrimination, you can filter by all sorts of different things, and then you can find the one that is really relevant for you, where that panel made a decision that applies to something that you are trying to argue for. And then when you are in court, you can say, I'd like to bring everyone's attention to this case, and they should be able to access the same case as you, but you can also have printed copies that you refer to. And you can say, in the Employment Appeals Tribunal case of so-and-so versus so-and-so, the judge determined that in situations where this happens, this should be how the judgment is made. And you can then use that to frame the way the judge is thinking and the panel are thinking about your case, so that the decisions they make are the decisions that you need them to be making. I hope this video has been helpful to you. Please do come back, watch my other videos, and like and subscribe and all those things I'm supposed to ask you to do. And I'll see you on the next one.